There is an order passed by Lordships on 20 September 22. I just read, your Lordships need not open, my Lords. We set down the case for hearing from 1st November 22 onwards, and it is expected that in two half-day sessions of 1st and 2nd, the matter should be concluded. In the unforeseen eventuality of a spillover, we will take it on Thursday, that is 3rd November 22.
That arose because that time there was to be afternoon also some other session. Now when constitution benches are sitting, they are sitting through the day. So
we just wanted that to be.
So we will. I don't think we will go to. Hopefully, we will not go to Thursday. We should be able to wind up between today and tomorrow.
Yes, yes. I'm just for our
that understanding was because earlier since morning the three judges bench reference bench used to sit.
I understand.
Two judges bench. I presume that the constitution bench will also sit accordingly in terms of the chief justice.
I bow down.
Right now, he says the constitution bench the day it sits, there will only be an alternative bench.
Not question. I raised this question so that other matters we can accordingly adjust. That was the only purpose.
In fact, the court master is asking, the other lawyers are asking. I said they should ask their colleagues how long the matter will go on. How can we say?
No, no. We were confused only on that half day.
No, that arose because of this.
Understood. I bowed. My learned friend, my lord, would take, my lord, we have broadly, my lord, understood. My learned friend would take about 40 minutes. I asked him. Thereafter, my lord, Mr. Desai is to argue on a point which I am, my lord, respectfully urging has not been referred.
Okay.
What is 197? What is the scope? The retrospectivity of Subramaniam Swami is referred, but that I'll point out when he starts. Thereafter, Mr. Datar, and thereafter my learned friend. And
actually, the lead matter is the appeal of the union, but I think they want us to start. The lead matter is the CBI's appeal matter. But
no, I am happy with the judgment. They persuaded the court for a reference.
Yes, so I'm just saying.
I have no difficulty. Whoever
in the CBI has filed an appeal.
Yes.
Is it the CBI doesn't want to press the appeal?
No. The sequence is arranged. We were happy with the view taken. I'm not
saying a view taken by this court in before the reference or
no. The appeal is the judgment impugned in CBI's appeal is before Subramaniam Swami.
Okay.
But my learned friend Mr. Datar persuaded the court to refer it to a larger bench because according to him there are some issues. Otherwise, we are not saying that it applies prospectively. It doesn't apply retrospectively.
What happened was both these judgments came before the judgment of Dr. Subramaniam Swami. Then we found out that there is a judgment of Transmission Corporation, which had raised the question that if an immunity was there, can that immunity be taken away retrospectively? So what is the scope of immunities given in criminal cases vis-a-vis Article 20? Unfortunately, the Electricity Act was amended and that reference became infructuous. So then the Supreme Court passed a 2-line order saying that in view of the amendment to the Electricity Amendment Act, we are not going to answer this question. When our matter came up, I was requesting the court and I was able to persuade the court to say that this is a larger question as to what happens. And the second question also, which we said it was not exactly mentioned. The second question is, if Subramaniam Swami has struck down a law in 2014, which was passed in 2004, what happens in between to those acts which have taken place? So that's how
retrospectivity or otherwise.
145.3.
On a very simplistic notion, you begin. Is that you begin? Today you begin.
Yeah. Yes, only one thing, Dr. Kishore, he's brought, because of age and his health, he wanted.
If he wants to begin, no difficulty.
Yes, let him.
They are on the same side.
A lot of research also, so he wanted.
I would like to address this.
The only thing, we had suggested the sequence, Dr. Kishore first, then Mr. Desai, because my Lord Justice Khanna raised the question that since your 5-judge bench is constituted, let us also examine this issue of sanction. So we divided the work. Lordship said, please finish it quickly so nobody repeats. So this 197, 19, etc., Mr. Desai will argue. Then
Lord,
only
one thing, Lord, I must on this clarify. Lord, your Lordships are aware. The question arose whether Subramaniam Swami judgment is prospective or retrospective. Whether 6A would apply to pre-Subramaniam Swami judgments or not. Section 197, whether what is official duty, what is not official duty, that's not even referred or not even dealt with by in the reference. That question doesn't arise.
Begin somewhere, we'll see.
No, I understand, Lord, but so they are seeking your lordships.
Between all of you are good for the day. So I don't want to keep the other lawyers.
Tomorrow, yes, Lord.
At least you are good for the day.
At least, yes.
Hopefully less. Hopefully less.
So, my lord, I would be urging, my lord.
Hope doesn't. I often am very skeptical of these hopes. So we'll ask the other alternative matters will not be taken up today, so they may not become.
But if your lordship sees the order of reference, even remotely, the scope of 197 is not arising.
Let us see when he begins, he'll explain how it arises.
He felt that there are some two different judgments. Mr. Desai mentioned, and your lordship will not put a query. That's all. There is no reference. There needs to be some.
Let's begin. Please read the reference order. So start.
Let's start.
Then let's begin. So the notes also got circulated at the nth minute.
Because there may be several judgments taking contrary view unconnected with this reference. So all will not be. We also do not know. Yesterday, my lord, very honestly, yesterday when we received a compilation of judgment on 197, my learned friend inquired from them that why 197, what is 197 scope, what is official duty? He said, no, this is also we are going to argue. That my lord, put us on a little alert that this is not even contemplated by us.
You were on alert, we got things in the morning, so we are not on alert, let us begin.
He was lucky he got it.
We have come with this one mind, clean mind.
Just for housekeeping purposes, Lordship, we have filed convenience compilation. I filed my compilation. Dr. Kishore wanted to file his. So if the Lordship is referring to anything, I've got my volume which includes a referral order. That's one.
Okay. You should refer to the compilation. Give the compilation convenience.
Yes. My compilation. I don't know if it's in a spiral bound or book form. It's at page 128. Yes, well,
I got pulled out of my vacation in Bombay because I was told that there's this issue which requires some assistance.
So I'll be able to satisfy Allah.
This is a part of this. So I am a little
Question is, you are
outside.
usefully, productively, and in many manners, gainfully pulled out.
Yes. The last part bold and underlined, my lords. By yes, emphasis supplied by me. Your lordships have the reference order.
They're just giving us the compilation which is filed, which has the reference order.
Yes, in my compilation also. There you go.
page 128. No, I'll just read the referral order, then Mr. Kishore can continue.
Mr. Kishore, you have your seat, you read the reference order and then you begin.
I'll finish the referral order and you can continue.
On merit, begin after the reference order. Okay.
No. This is index to convenience compilation. Is that what you are?
Pardon?
Are you reading? I have an index to convenience compilation.
Yes. And the petitioner is Manjit Singh Bali.
Yeah.
No, it is CBI versus Kishore.
There are two petitions. There are two matters. One from Bombay.
I am happy.
But that's a different matter, you know.
The lead matter is Dr. Kishore. I'm also a SLP. My SLP is there.
Lord, your lordships, only a minute. Lord, for
What difference does it make? I think they just
no, Lord, there are two orders.
Just have a seat. We'll first hear the reference order. Reference order is only one. Are there multiple reference orders? No.
There are two, my lord.
No, actually, there's one reference order which summarizes it, and there's a reason given. That's all.
Lord, kindly see 130 of his compilation. That's the reference order. I am not, my lord, on anything else. My lord, let us read it as it is. But my learned may not expand the scope. That's the only concern.
We'll see.
Yes, it's ultimately for your lordships to decide. A prosecution.
My lord, page 128.
Only a minute. I'll read fully.
All right.
I'll read for you. If you want me to read 128. 128, yes.
It starts from 130.
The order begins.
130.
Summary is in page 128, 129. The detailed reasons are given from page
130.
It's a daily order and a judgment.
Okay.
I am reading the longer one so that your lordship gets the entire.
Let us see 120. Let us have 129. Then go to 130.
129 I'll read, my lord. The provisions of Section 6A1 do indicate that for officers of the level of Joint Secretary and above, a kind of immunity has been provided for. Whether there can be a deprivation of such immunity by a retrospective operation of a judgment of the court in the context of Article 20 of the Constitution of India is the moot question that arises for determination. For the aforesaid reasons and having regard to the provisions of Article 145(3) of the Constitution of India, we refer the aforesaid question to a larger bench, for which purpose the papers may now be laid before the Honorable Chief Justice. So this is the only question. This is now, what I read was the summary. The detail is this.
Detailed order.
Yes, I'll skip what is not relevant. A prosecution under Prevention of Corruption Act was sought to be questioned by the respondent accused on the basis of the provisions contained in Section 6A1 of the Act, which was brought in by an amendment in 2003. 6A reads as under, your lordships can skip for the time being. The Delhi High Court, before whom the challenge was brought, answered the question by holding that respondent accused was entitled to the benefit of the said provision. Accordingly, the High Court took the view that matter required fresh consideration for grant of previous approval under Section 6A1 of the Act. Aggrieved, the CBI is in appeal. We have heard. Then 4. The provisions of 6A1 of the Act has been held to be unconstitutional, being violative of Article 14 of the Constitution of India by a Constitution bench. That is Subramaniam Swamy. The judgment of the Constitution bench is, however, silent as to whether its decision would operate prospectively or would have retrospective effect. Though a large number of precedents have been cited at the bar to persuade us to take either of the above views, we would support the case of rival parties. We are of the considered view that this question should receive consideration of a Constitution bench in view of the provisions of Article 145(3) of the Constitution. Then, as my learned friend Mr. Datar said, in Transmission Corporation, the precise question that has arisen before us had been referred to a Constitution bench. Paragraph 15 and 21 dealing with the said question read as follows. Whether constitutional guarantee enshrined in Clause 1 of Article 20 is confined only to prohibition against conviction for any offence except for violation of law in force at the time of commission of the act charged as an offence and subject to a penalty greater than that which might have been inflicted under the law in force at the time of commission of the offence, or it also prohibits legislation which aggravates the degree of crime or makes it possible for him to receive the same punishment under the new law as could have been imposed under the prior law, or deprives the accused of any substantial right or immunity possessed at the time of commission of the offence charged, is a moot point to be debated. However, as the interpretation of Article 20 and its scope and ambit is involved in these proceedings, we read in para 15 of this order to a larger bench for consideration. However, the Constitution bench in so-and-so, 2010, I skip, as my learned friend says, it has become in fact to be protecting the substantial right or the immunity enjoyed by an accused at the time of commission of the offence for which he has been charged. The provisions of Section 6A1 extracted above do indicate that for officers of the level of Joint Secretary and above, a kind of immunity has been provided for. Whether there can be a deprivation of such immunity by a retrospective operation of a judgment of the 20 of the Constitution is the moot question that arises for determination in the present case. For the aforesaid reasons and having regard to provisions of Article 140, refer the aforesaid question to a larger bench